The Mississippi State Medical Examiner's Office completed the autopsy on Nolan Wells on July 31, 2026. 25 days after conducting the examination. 25 days after removing Nolan's lungs, his throat tissue, the specific organs whose findings would answer the most critical forensic questions in this investigation. The report is done. The conclusions have been reached. The Mississippi State Medical Examiner knows what those lungs contained, and the state is not telling anyone. Not the public, not the press, not Ben Crump, not Nolan's parents, Christine Wansley and Elmore Wansley, who have been waiting since July 6th for the official answer to what killed their son. The family does not know what the state's autopsy found. Their attorneys do not know. The independent pathologist, Dr. Roger Mitchell, who documented in his own report that the lungs and throat tissue were missing when he received Nolan's body. He does not know what the state found in those organs. The results are sealed. District Attorney Angel Myers McIlrath confirmed why on July 23rd, before the completion of the report, in a video she released publicly. She said, "Every death in the county, except those of natural causes and non-criminal car wrecks, is presented to your grand jury." She said, "Many people don't know that we have handled death investigations in this manner my entire career. The grand jury will receive the autopsy report. The grand jury will be the first body outside the official investigation to learn what the Mississippi State Medical Examiner found. And the grand jury will determine whether what the report contains is sufficient to bring formal charges against anyone. This is forensic disconnect. And today we need to talk about what it means that the state has finished the autopsy, sealed the results, and left every question this case has raised. The missing lungs, the deep red tissue at the base of Nolan's skull, the cannot rule out neck injury, the phone on the boat, unanswered while the family waits and the investigation builds toward a grand jury that has no announced timeline. It is also important to note what Mitchell did not find. The independent autopsy found no skull fractures, no major fractures, and no deep tissue injuries that clearly explained Wells's death. The deep red subcutaneous tissue at the occipital bone is a finding, but it exists in a body that showed no obvious trauma, no fractures, no lacerations, no blunt force injury visible in the tissue that was available to examine. The cannot rule out neck injury exists precisely because the throat tissue was missing, not because Mitchell found evidence of neck injury. He found an absence of evidence that could rule it out. Before we go further, subscribe and hit that notification bell. Here at Forensic Disconnect, we unlock the cases that deserve to be remembered. Subscribe. Let's start with what the completion of the autopsy actually means in the specific legal and investigative framework of Jackson County, Mississippi. Because the completion of the report does not mean the investigation is over. It means one specific component of the investigation, the forensic pathology examination, has produced its conclusions. Those conclusions are now part of the evidence package that the district attorney is assembling for the grand jury. The DA's statement on July 23rd is the specific public explanation of the sealing policy. In Jackson County, under McIlrath's tenure, every death that is not clearly natural causes or a non-criminal car accident goes to the grand jury. The autopsy report goes with it. The grand jury hears the evidence in private, under oath, with subpoena power. It decides whether the evidence supports charges. This is not unusual procedure in Mississippi. It is how McIlrath's office has operated throughout her career. The specific application of that procedure to the Nolan Wells case, a case with national attention, a family represented by Ben Crump, an independent autopsy that found undetermined cause of death with missing organs, means that the most anticipated forensic document in this investigation will not be public until the grand jury process has been completed. When will that be? Nobody is saying. The investigation must be complete before the grand jury convenes. The investigation is not yet complete. The toxicology has not been released. The phone forensics are ongoing. The grand jury has not been scheduled. So the state has the answer. It has been sealed. And the investigation continues. Now let's go to what the specific sealing of the results means for the parallel investigation being conducted by Ben Crump and the Wells family. Because the family's independent investigation, which produced the independent autopsy with its undetermined finding and its missing organs documentation, is now in a specific position relative to the state's sealed results. The state knows what the lungs contained. The independent pathologist does not. The state knows what the throat tissue showed. The independent pathologist cannot rule out neck injury because that tissue was missing when he examined the body. The family's legal team has been demanding for weeks that the state share those findings with Dr. Mitchell. The state has not done so. That specific refusal to share the findings with the independent pathologist, even as the results are being sealed for the grand jury, is the specific tension that Ben Crump has been pressing publicly. He said at a news conference on July 30th that the legal team is actively working to get Dr. Mitchell access to the parts of Nolan's throat he was unable to examine, as well as photographs and observations made when Nolan was found. The throat. Dr. Mitchell is still trying to get the throat tissue. The state conducted its autopsy on July 7th. The independent pathologist received the body and found the throat tissue missing. And nearly a month later, Mitchell is still working to get access to the specific anatomical material whose examination would allow him to address the cannot rule out neck injury finding in his report. Mitchell wrote something specific in his report that has not received enough attention. He wrote, "It is important to reiterate that this finding could not have been observed in the first autopsy because the posterior head and neck dissections were not performed. The posterior head and neck dissections were not performed in the first autopsy." The state's July 7th examination did not include the specific dissection procedure that would have examined the specific region where the deep red tissue was found and where neck injury cannot be ruled out. Either the state's autopsy did not perform those dissections, which would mean the state's report also cannot speak to neck injury, or the dissections were performed, but the material was not returned to the body before the independent examination. The specific clarification that Mitchell is seeking, whether the throat tissue exists as part of the state's retained material, and whether he can examine it, is the clarification that would resolve the most significant limitation of his independent report. The state has not provided that clarification. Now let's address the arrest. Because buried in the reporting on the autopsy completion is a specific detail that most coverage has treated as a footnote, but which is its own bombshell. A man was arrested for making threats against a public official connected to the Nolan Wells case. A man arrested for threatening a public official. The FBI had already confirmed it was investigating threats against witnesses and officials in the Nolan Wells investigation. Those threats were serious enough to require federal involvement. And now, in the period coinciding with the autopsy's completion, an actual arrest has been made. The specific public official who received the threats, the specific nature of those threats, and the specific identity of the person arrested have not been fully detailed in public reporting as of the completion of this video. What is confirmed is that someone connected to the investigation, a public official, someone with an official role in the case, received threats serious enough that the person making them was arrested. That arrest tells you something specific about the social pressure surrounding this investigation. It tells you that the threats are not abstract internet comments. They are specific, serious, and actionable enough that law enforcement made an arrest. It tells you that someone connected to this case, someone whose role in the investigation has attracted enough attention to generate targeted threats, is at sufficient risk that their protection requires a criminal arrest. Who threatened whom and why, and what that person's connection to the case is. Those are the specific questions that the investigation holds, and the public does not. But the arrest is real. The FBI involvement is real. And the specific escalation from threats to an actual arrest tells you that the social pressure on this case has reached a level that is affecting the safety of the people involved in it. Now let's go back to the specific significance of what the state autopsy's completion means for the grand jury timeline, because the completion of the autopsy moves the investigation one step closer to the grand jury. But it does not complete the investigation. The DA said the grand jury receives the case when the investigation is complete. Complete means the autopsy, the toxicology, the phone forensics, and the full witness account record are all finalized. The autopsy is now complete. The toxicology is pending. It is a separate component of the forensic work, and its results are not yet part of the public record. The phone forensics are ongoing. The witness accounts are still being processed. The specific items still pending are the specific items that will determine whether the grand jury is convened in September, October, or later. Each pending item is a variable. The toxicology could come back this week or in 3 weeks. The phone forensics could produce results imminently or require additional time. The specific combinations and interactions of those timelines will determine when McIlrath is ready to present the case. But the autopsy being complete is the specific milestone that signals the grand jury is closer. The state has its forensic conclusions. Those conclusions are sealed. And when the remaining forensic work is done, the grand jury will hear everything. Now let's also think about what the sealing policy means from the family's perspective. Because the specific experience of being Nolan Wells' parents right now, knowing that the state has completed its autopsy, knowing that the report exists, knowing that the answer to what killed your son is in a document that the state holds and has sealed, is the specific experience of people who are waiting for information that legally exists but that they are not allowed to have. Christine Wansley confirmed Nolan's phone was found on the boat. She has been posting updates to supporters. She has been present at press conferences. She has been asking, publicly, specifically, and with the specific force of a mother who is not going to stop asking, why the investigation has not produced an answer. Elmore Wansley said his son always said yes, sir. He said his son came back with the group, always, until July 4th. He said he does not believe Nolan stayed alone. The state has the answer to what killed their son. It has sealed it. The grand jury will eventually hear it. The grand jury is waiting for a completed investigation. The investigation is not yet complete. Now let's go to what we know about what the independent autopsy found and what the state's report is expected to address. Because the convergence of the two reports when it eventually happens in the grand jury room is where this case will be decided. Dr. Mitchell's independent report found cause and manner of death undetermined pending further investigation. Deep red subcutaneous tissue at the occipital bone, the base of the skull. Cannot rule out injury to the neck, cannot determine whether Wells was conscious or unconscious, forced or unforced before entering the water. Significant limitations because the lungs and throat tissue were missing. What the state's report is expected to address. What the lungs contained. Water consistent with drowning, or something different. What the throat tissue showed. Evidence of neck injury or its absence. The complete toxicological findings. What was in Nolan's system on July 4th. The specific cause and manner of death as determined by the Mississippi State Medical Examiner's Office. Those two reports, the independent report with its undetermined finding and its documented limitations, and the state's sealed report with its complete findings, will eventually be presented to the grand jury side by side. The grand jury will evaluate them together. If they agree on cause of death, the picture clarifies. If they disagree, the grand jury will need to evaluate the specific reasons for the disagreement, including the specific forensic significance of the state having organs that the independent pathologist did not have access to. Ben Crump wants Mitchell in the room when that happens. He wants the independent pathologist who documented the missing organs and the cannot rule out neck injury to be present when the state presents its findings from those same organs. That is the specific accountability demand that Crump has been pressing, and that the sealing of the results has not resolved. Now let's also address the specific significance of what authorities have said publicly about the cause of death. Because multiple news reports have noted that authorities believe it is likely that Wells's death was an accidental drowning. Likely. They believe it is likely. That specific language, not confirmed, not determined, not concluded, is the specific language of an investigation that has reached a preliminary assessment, but has not yet finalized its findings. The state's sealed autopsy report presumably contains the specific forensic conclusion that the assessment is based on. If the lungs contained water consistent with drowning, that is the forensic basis for the likely accidental drowning assessment. If the lungs did not contain water consistent with drowning, the likely assessment would be harder to sustain. The sealing of the results means the public cannot evaluate the basis for that assessment. The family cannot evaluate it. The independent pathologist cannot evaluate it. Only the grand jury, when the investigation is complete, will receive the specific evidence that explains why the authorities believe what they believe. That is the specific power of the sealed autopsy in this case. It is not just an absence of information, it is the specific evidence that contains the answer to the question Nancy Grace asked and Christine Wansley asked, and everyone who has followed this case for a month has been asking. What was in the lungs? The state knows. The state has sealed it. The grand jury will find out. Let's go deeper into the specific legal significance of the DA's sealing policy and what it tells us about how McIlrath is approaching this case. The statement she made on July 23rd, before the autopsy was even confirmed complete, is the specific public explanation of a policy she says she has followed throughout her career. Every death in the county except natural causes and non-criminal car wrecks goes to the grand jury. The autopsy report goes with it. The grand jury hears it first. That policy, applied consistently, means that the Nolan Wells autopsy report will not be released to the public before the grand jury receives it. It will not be released to the family before the grand jury receives it. It will not be released to Ben Crump or Dr. Mitchell before the grand jury receives it. The grand jury is the first body outside the official investigation to hear what the state's autopsy found. This is not unusual in Mississippi. It may feel unusual to people following this case who are accustomed to major cases where autopsy results are released to the public relatively quickly. But it is the specific procedural framework of Jackson County, applied consistently by the current DA. What that framework means in practice is that the specific tension between the family's independent investigation and the official investigation will not be resolved publicly until the grand jury has convened and heard both reports. The independent pathologist's undetermined finding with its documented limitations. The state's sealed findings with the complete examination. The grand jury will have both. The public will have neither, until the grand jury process produces an outcome that requires the evidence to become part of a public record. If the grand jury returns an indictment, the evidence package, including the sealed autopsy, becomes part of the public criminal proceedings. Defense attorneys will have access to it. It will be the subject of trial testimony. The public will eventually learn what it contains. If the grand jury declines to indict, the sealed autopsy may remain sealed indefinitely. The state is not required to release autopsy reports that are part of ongoing investigations, and a no bill from the grand jury does not automatically transform the evidence into a public record. That specific possibility, the grand jury declines to indict, the autopsy remains sealed. The family never learns publicly what the state found in their son's lungs, is the specific outcome that Ben Crump is working to prevent. His demand that Mitchell get access to the throat tissue is not just a forensic request, it is a legal strategy. If Mitchell can examine the complete body, including the material the state retained, and produce a comprehensive independent report, that report exists in the public record regardless of what the grand jury decides. The state has sealed the answer. Crump is building the independent record that might eventually make the sealed answer irrelevant. Now let's also address what the completion of the autopsy tells us about the likely timeline for the grand jury. Because DA McIlrath has said the investigation must be complete before the case is presented, the autopsy is now complete. What remains? The toxicology. Bailey C. Martin, the Mississippi Department of Public Safety spokesperson, confirmed on July 31st that the autopsy report was complete. The toxicology report from the medical examiner's office was not yet completed as of that date. The toxicology is a separate component. Blood and tissue samples analyzed by a forensic toxicology laboratory, testing for alcohol, controlled substances, prescription medications, and other compounds. Standard processing time is 4 to 8 weeks from submission. The samples were taken during the July 7th examination. At 4 to 8 weeks out, the toxicology results are expected to return between early August and early September.
If they are already back, if the standard timeline has been met, they may already be part of the sealed package. If they are still pending, the grand jury cannot be convened until they arrive. The phone forensics. The FBI's joint examination of Nolan's phone with the Wells family's attorneys is ongoing. There is no announced timeline. The results, when they are available, will be part of the investigation's evidence package. The 60 witness accounts.
The investigation has interviewed approximately 60 people. Whether those accounts are fully processed, whether any inconsistencies have been resolved, whether any additional interviews have been conducted based on what the accounts contained, is information the public does not have. The convergence of those three pending items, toxicology, phone, witnesses, is what the DA means by complete. When all three are in hand, the grand jury can be scheduled. At current pace, that convergence is most likely in September or October. The autopsy is done. The clock is running on the rest. Now let's also think about what the likely accidental drowning assessment from authorities means in the context of the sealed autopsy. Because the specific phrase, authorities believe it is likely an accidental drowning, has been present in the coverage since July, and the completion of the autopsy has not changed that public-facing characterization. If the state's sealed autopsy found water in the lungs consistent with drowning, the likely accidental drowning assessment has forensic support. The state can maintain that characterization while the full investigation is completed. The grand jury would receive an autopsy that supports the likely assessment, and the grand jury might well decline to bring charges. If the state's sealed autopsy found something inconsistent with drowning, or found the specific findings that would make the independent pathologists cannot rule out neck injury more significant, then the likely accidental drowning characterization becomes harder to sustain. The authorities' public position would be inconsistent with their own sealed forensic findings, and the grand jury would need to reconcile that inconsistency. The sealed autopsy is the specific document that would allow us to evaluate the likely assessment. Because we cannot see it, we cannot evaluate it. We can only note the specific tension between what the independent pathologist found and did not find, and what the authorities are willing to say publicly about what they believe. Nancy Grace said, "Somebody's lying." The state's sealed autopsy contains the specific evidence that would confirm or challenge that assessment. The grand jury will find out. Now let's address the man who was arrested for threatening a public official. Because this detail, confirmed in multiple reports covering the autopsy completion, is the specific piece of new information that gets lost in the larger forensic story, but that tells you something important about the state of the investigation and the people connected to it. The reports describe a man arrested for making threats toward a public official connected to the case. The specific official, the specific nature of the threats, and the specific identity of the person arrested have not been detailed in the available public reporting. But the existence of an arrest matters. The FBI had already confirmed it was investigating threats against witnesses and officials in the Nolan Wells case. That investigation has now produced an arrest. Someone connected to this case. Someone in the specific official capacity of a public official, someone whose role in the investigation has attracted enough hostile attention to generate specific, actionable threats, was threatened seriously enough that law enforcement made an arrest. In the context of a case where Bart Edmiston Jr.'s family has received death threats, where multiple cease and desist letters have been issued, where Kimber Lee has been notified by an attorney, where the social media conversation has produced the specific toxic environment that high-profile racially charged cases generate. In that context, an arrest for threatening a public official is the specific escalation that moves this from internet drama to criminal consequence. Who was threatened? Who made the threat? When those details become public, they will add a specific dimension to the case's social landscape that is not currently visible. What we know now is that the FBI's investigation of threats produced a result, an arrest. A specific accountability for a specific threat. The investigation continues. Let's also go deeper into what the specific mechanics of the grand jury process mean for the Wells family and their ability to participate in, or even observe, the proceeding that will ultimately determine accountability for their son's death. Grand jury proceedings in Mississippi, as in most American jurisdictions, are secret. Not just sealed from the public, secret from the family of the victim. The Wells family will not be in the room when the grand jury hears the evidence. They will not hear the state's autopsy findings presented to the 12 grand jurors. They will not hear the testimony of the 60 witnesses who have been interviewed. They will not hear the toxicology results. They will not hear the phone forensics. The grand jury's secrecy is a foundational principle of American criminal procedure, designed to allow witnesses to testify freely, to allow the presentation of evidence without the pressures of public scrutiny, and to allow the grand jury to reach its conclusions without external influence. In an ordinary case, that secrecy serves those purposes effectively. In the Nolan Wells case, the grand jury secrecy means that the family of an 18-year-old who died on a Mississippi barrier island under disputed circumstances will sit outside the process that determines whether anyone is held accountable for that death. They will not know what was in the lungs until the process is complete, and either an indictment reveals it or the case closes without charges. Ben Crump's demand that Mitchell be included when the case is presented is the specific mechanism by which the family's independent investigation can be part of the grand jury record. If the DA agrees to include Mitchell's independent findings alongside the state's findings, if the grand jury hears both reports rather than just the state's, the family's perspective is represented in the proceeding, even though the family cannot attend. McIlrath has not publicly committed to including Mitchell. The decision of what evidence to present to a grand jury is the DA's decision. She can present the state's evidence and the state's witnesses. She can also choose to present additional evidence, including the independent autopsy, that provides the grand jury with a more complete picture. Whether she does that will be one of the specific accountability measures that Ben Crump is watching for. Now let's think about the specific parallel between the sealed autopsy and the sealed phone. Both of the most significant pieces of physical evidence in this case are in the possession of official entities who have not shared them publicly. The state has the autopsy findings. The FBI has the phone forensics. Neither has been released to the family, to the independent pathologist, or to the public. The sealed autopsy will eventually go to the grand jury. The phone forensics will eventually be part of the complete investigation package that the DA presents. In the grand jury room, everything will be on the table. The grand jurors will hear what was in the lungs, they will hear what was on the phone, they will hear the 60 witnesses under oath, and then they will decide. That decision, to indict or not to indict, will be the first public signal of what the sealed evidence contains. An indictment says, "The sealed evidence taken together is sufficient to support the belief that a crime occurred and that a specific person committed it." A no bill says, "The sealed evidence taken together does not support that conclusion." Either outcome will produce the specific public consequence of revealing, through the legal record, something about what the sealed autopsy and the sealed phone contain. The family is waiting for that signal. Crump is waiting. Nancy Grace is waiting. The $175,000 reward is waiting. The nation that has been following this case for a month is waiting. The autopsy is complete. The grand jury is closer. The answer is coming. Nolan Wells made salmon for his family on July 3rd. He got on a boat on July 4th. His phone was on the boat. His body was in the water. The state has his lungs and the complete autopsy findings. The findings are sealed. The grand jury will find out what those findings contain. The investigation is not finished. Let's go to what this specific moment, the sealed autopsy, the pending toxicology, the ongoing phone forensics, means for the specific people who have been most visible in pressing for accountability. Christine Wansley has been posting to social media throughout this investigation. She confirmed the phone was on the boat. She has been updating supporters. She has been attending press conferences. She is the mother of a young man whose state autopsy results exist in a sealed document that she is not allowed to see. What does it feel like to be her right now? To know that the answer to what killed your son exists in a document, that the Mississippi State Medical Examiner knows, that the document is sealed, that you will not know, officially, legally, finally, until a grand jury whose proceedings you cannot attend receives it in a proceeding that could take weeks or months more. Elmore Wansley said, "If you go with a group, you come back with the group." He said it because his son always said, "Yes, sir." He said it because his son came back always, until July 4th. And now the state has the answer to what happened after July 4th in a document he cannot read. The grand jury is the mechanism. The grand jury will hear the answer. The grand jury will decide, but the parents are waiting. Now let's also address what the independent autopsy's specific language about the posterior head and neck dissections means in the context of the completed state report. Mitchell wrote, "It is important to reiterate that this finding, the deep red subcutaneous tissue at the occipital bone, could not have been observed in the first autopsy because the posterior head and neck dissections were not performed. This sentence is remarkable. It says that the first autopsy, the state autopsy conducted on July 7th, did not perform the specific dissection procedure that would examine the posterior head and neck region. The deep red tissue that Mitchell found was not something the state saw because the state did not perform that specific procedure. That means the state's sealed report may not address the deep red tissue at all. If the posterior head and neck dissections were not performed in the first autopsy, the state's report has no findings on the specific anatomical region that Mitchell's report flagged as significant. The state's report, however complete, may have a specific gap, a gap that corresponds exactly to the most concerning finding in the independent pathologist's report. This is a specific, significant forensic tension. The independent pathologist found something, deep red subcutaneous tissue at the base of the skull, adjacent to the neck, that the state's first autopsy did not examine because the relevant dissections were not performed. The independent pathologist cannot rule out neck injury because the throat tissue was missing. And now the state's completed report may not address either of those specific findings because the procedures that would produce those findings were not part of the original examination. Ben Crump is working to get Mitchell access to the throat tissue, to the specific material that would allow the independent pathologist to examine the neck and reach a conclusion about the cannot rule out neck injury finding. If that access is granted, Mitchell can supplement his report. If it is not granted, the independent report will remain limited in exactly the specific ways that matter most. And the state's sealed report, complete, according to Bailey C. Martin, confirmed on July 31st, may not address those specific limitations because the specific procedures were not performed. The grand jury will have the state's complete report. If that report does not include posterior head and neck dissection findings, the grand jury will not have the specific forensic information that Mitchell's report flagged as significant. The grand jury will be evaluating an incomplete forensic picture, not through any malfeasance, but through the specific procedural decisions made during the first autopsy. That is the specific forensic gap that Mitchell's access to the throat tissue would close. That is why Crump is pressing for it. That is why the answer is not yet complete, even though the state's autopsy report is. Now let's bring it all together one final time. Because the Nolan Wells investigation has reached the specific moment where all of the evidence is assembled or nearly assembled, the grand jury is the next step, and the question that has been driving this case for a month is waiting for an official answer. The state autopsy is complete. The results are sealed. The state believes it is likely an accidental drowning. The specific forensic basis for that belief is in the sealed report. The independent autopsy is undetermined. The independent pathologist cannot rule out neck injury. The independent pathologist could not perform the posterior head and neck dissections because the relevant procedures were not performed in the first autopsy, and the throat tissue was not present. The toxicology is pending. The phone forensics are ongoing. The grand jury is waiting. A man has been arrested for threatening a public official connected to the case. The FBI is investigating. 60 witnesses have been interviewed. The investigation is not yet complete. $175,000 is waiting for the truth. Nancy Grace said somebody's lying. Christine Wonsley asked why we are so quick to call this an accident. Elmore Wonsley said his son always came back with the group. The boat came back without him. The phone was on it. The state has the answer. It is sealed. The grand jury will find out. Nolan Wells made salmon for his family on July 3rd. He got on a boat on July 4th. The investigation will tell his parents what happened after that. Let's also address the specific significance of what authorities have confirmed about the investigation's direction. Because multiple officials, the DA, the sheriff, the state's public safety spokesperson, have made specific public statements that, taken together, describe an investigation that is moving toward a specific conclusion. McIlrath said, "Every death in the county is presented to your grand jury." She said it before the autopsy was complete. She said it as a general policy statement, not as a response to pressure about this specific case. The policy applies equally whether the case closes as an accidental drowning or produces a homicide indictment. The Mississippi Department of Public Safety spokesperson, Bailey C. Martin, confirmed the autopsy completion and did not respond to questions about when the report would be released publicly. The non-response is itself a statement. The state is not volunteering information about the report's timeline or contents. The sheriff's office has maintained throughout, no foul play identified at this time. That specific language, at this time, has been consistent across every official statement from the JCSO. It is not, no foul play occurred. It is, we have not identified foul play at this time. The qualifier is doing specific work. It leaves open the possibility that foul play will be identified as the investigation progresses. Authorities have told multiple news outlets that they believe it is likely an accidental drowning. Likely, not confirmed. Belief, not conclusion. The specific forensic basis for that belief, whatever the sealed autopsy contains, has not been shared. Those three statements together, every death goes to the grand jury. No foul play at this time. Likely accidental drowning. Describe an official investigation that is moving toward a grand jury with a working hypothesis of accidental drowning while maintaining procedural openness to a different conclusion. The grand jury will either confirm the working hypothesis or challenge it. The specific evidence that would challenge it, if the lungs do not show consistent drowning patterns, if the toxicology shows something unexpected, if the phone forensics reveal deleted content suggesting a specific sequence of events, is the evidence that is still pending or sealed. The evidence that would confirm it, water in the lungs, toxicology consistent with impaired swimming, phone content showing voluntary stay, is the evidence that, if it exists, is in the sealed report. The investigation is moving. The grand jury is closer than it has ever been. Now let's also sit with the specific significance of Dr. Mitchell still trying to get the throat. Because that detail, the independent pathologist actively working to obtain the throat tissue that was missing when he examined Nolan's body, is the detail that tells you the independent investigation is not settling for the sealed state findings. Mitchell performed the independent autopsy on July 10th. He found the throat tissue missing. He documented the finding. He wrote his report with the cannot rule out neck injury language, and the posterior head and neck dissections were not performed note. He submitted his findings, and then, 3 weeks later, as of the Crump press conference on July 30th, he is still working to obtain the throat tissue. That persistence is significant. Mitchell is not satisfied with the independent examination he was able to conduct. He believes the throat tissue, whatever the state retained, whatever was in Nolan's body that was not returned before the independent examination, contains information that matters for the complete forensic picture. The state has that tissue. Whether the state will share it with Mitchell is the specific question that has not been resolved. Whether the state performed the posterior head and neck dissections on that tissue in their own examination, and whether those findings are part of the sealed report, is information the public does not have. If the state did perform those dissections and found nothing of concern, sharing the results with Mitchell would resolve the cannot rule out neck injury finding. If the state did not perform those dissections, as Mitchell noted was the case in the first autopsy, then neither report has addressed the specific anatomical region where the independent pathologist found the deep red tissue. That is the specific gap. That is what Mitchell is still trying to close. That is what the grand jury will need to evaluate, with whatever materials are available and whatever limitations exist in both reports. The autopsy is complete. The throat question is unresolved. The grand jury is the endpoint. And the sealed report is the specific document that contains whatever answers the state has reached. Nolan's parents are waiting. The grand jury is waiting. The answer is sealed. Let's do one final pass through everything this case has accumulated and what the sealed autopsy means for each specific piece of evidence that has been part of the public conversation. The GPS data places the boat's departure at 4:31 p.m. on July 4th. That fact is not affected by the sealed autopsy. The boat left at 4:31 p.m. regardless of what the lungs contained. What the sealed autopsy could affect is the interpretation of what happened between 4:31 p.m. and whenever Nolan entered the water. Whether the lungs show he was alive when he went in, or whether something happened to him before he reached the water. The CTO audio, with the 12 seconds that some listeners interpret as "is he dead," is not affected by the sealed autopsy. The audio exists regardless of what the lungs found. What the sealed autopsy could affect is whether the question heard in the audio was already answerable at the time it was asked. If the lungs show Nolan was alive when he entered the water, that he drowned, then the question "is he dead?" if it was asked in the background of that call, is asking about someone who is still alive. If the lungs show something different, if the pattern of findings is inconsistent with drowning, then the question takes on a different weight. The phone on the boat is not affected by the sealed autopsy. The phone was on the boat regardless of what killed Nolan. What the sealed autopsy could affect is the interpretation of why the phone was on the boat, whether it ended up there as part of an accidental departure or as part of something more deliberate. The deep red tissue at the occipital bone and the cannot rule out neck injury finding from the independent autopsy are the specific forensic elements that the sealed state autopsy most directly affects. If the state's report addresses those specific anatomical findings, if the posterior head and neck dissections were eventually performed as part of the first autopsy's complete examination, then the state's findings on those specific areas either confirm or challenge Mitchell's cannot rule out statement. If the state's report does not address those areas because the relevant procedures were not performed, then neither report resolves the question. The heavy alcohol document is not affected by the sealed autopsy. The specific description of heavy alcohol intake before disappearing is a separate finding, one that the toxicology will either confirm or contradict. The autopsy may include preliminary toxicological findings as part of the complete report, but the full toxicological panel is a separate document. The witnesses who saw Nolan at 6 p.m. are not affected by the sealed autopsy. That sighting happened or it didn't, regardless of what the autopsy found. What the sealed autopsy could affect is the interpretation of what happened to Nolan in the time between the 6 p.m. sighting and the discovery of his body on July 6th. Each of those pieces of evidence exists in relationship to the sealed autopsy, not replaced by it, not resolved by it, but potentially recontextualized by it. Depending on what the lungs contained, depending on what the throat tissue showed, depending on whether the posterior head and neck dissections produced relevant findings, the sealed autopsy could confirm the likely accidental drowning assessment, or it could create new questions that the grand jury must evaluate. The grand jury will see all of it together: the GPS data, the audio, the phone, the independent autopsy, the sealed state autopsy, the toxicology, the phone forensics, the 60 witnesses under oath. Together, those pieces will produce the official answer. The sealed autopsy is the piece that has been missing from the public's view of this case since July 7th. It is now complete. Its contents remain sealed. And the distance between complete and sealed is the specific distance that the family is living in. Knowing that the answer exists, not knowing what it says. Nolan made salmon for his family on July 3rd. He got on a boat on July 4th. His phone was on the boat. The state has his lungs and the complete autopsy findings. The findings are sealed. The grand jury will find out what those findings say. And when they do, the specific answer to what happened to Nolan Xavier Wells after he said goodbye on July 3rd and got on a boat on July 4th will be part of the official record of Jackson County, Mississippi. His parents are waiting for that record. The investigation continues. The autopsy is complete. The answer is sealed. The grand jury is coming. One final thought about what it means that the DA sealed the report and the state has not shared it with the family or the independent pathologist. McIlrath explained the policy clearly. Every death in the county goes to the grand jury. The policy is not specific to this case. It is not a response to the national attention. It is how Jackson County handles death investigations under her tenure. But the specific application of that policy to this specific case, a case where the independent pathologist has documented missing organs, where the family has demanded transparency, where Ben Crump has called on the state to share its findings, where national attention has made every procedural decision visible, means that the policy is being evaluated in a context it has never faced before. Is it appropriate to seal an autopsy report that the family of the deceased cannot see, in a case where the independent pathologist has documented specific limitations in his own examination that the sealed report might address? Is the policy that works for an ordinary county death investigation the right policy for a case that has produced a $175,000 reward, federal investigation of witness threats, a nationally prominent civil rights attorney, and a public demand for transparency? McIlrath has not addressed those specific questions. She has explained the policy and applied it. The grand jury will receive the report. The family will wait. The specific answer to those questions will come when the grand jury process is complete and the sealed report becomes part of whatever legal record the grand jury produces. The autopsy is complete. The answer is sealed. The grand jury is coming. Nolan Wells made salmon for his family on July 3rd. His phone was on the boat. His body was in the water. The state knows what the lungs contained. The grand jury will find out. His parents are waiting. If you have any information about what happened to Nolan Wells on Horn Island on July 4th, 2026, contact the Jackson County Sheriff's Office or the FBI's Jackson Field Office. Hit the like button. Subscribe to Forensic Disconnect. Drop a comment. What do you think the sealed autopsy found? And what do you think the grand jury will decide when they finally hear everything? We read every single comment. We will be back tomorrow.